So therefore, my lords,
What were you talking? This is a-
therefore, my lords, in sum, all that I'm saying
It
is
is a repetition.
that so far as my lords 3D is concerned, its impact is drastic. My lords, it will apply to age-old mosques, age-old properties, and 3D, my lords, really requires an absolute stay in my respectful sir.
I appear in the fifth of the 5 lead matters.
Thank you.
Only 4 have been. Lordship, I just have two points to make. That's all, Lordship. Not detailed submissions. 2 points which have not been made so far. Lordship, the first is
Everybody says that, but then
Lordship, and I'll keep my word, Lordship.
My lord, it's almost 3.5 hours. I'm not objecting, my lord.
no, 3 hours, 45 minutes.
Lordship, it's already been stated.
I have come from Srinagar, my lord, only for this matter because most of the property, Waqf property is there in Srinagar. Please give me.
Lordship,
You include your points in the
Clarification is distilled.
Lordship, it has already been
2 minutes, I will make question clear as far as Waqf is concerned.
How much time your side? How many? Who are going
We
to
are
argue?
5, but I'll start, my lord, and I'll cover, my lord, substantially, but will not take more than what they've taken. We can
You can't.
assure you.
No, you should take lesser than that,
Yes, certainly.
so that we should give them
So,
some
sir,
time
the
for
points
result.
which were not brought to your lordship's notice, my lord, half sections, etc. I mean, I'll have to show, my lord, what is
Lordship,
the
I'll
real
just take a minute.
purpose, intent, object.
Lordship,
It's a very important point. So,
please.
I'm better.
Then,
Better than his.
Now, there is a Waqf board also.
इसलिए नहीं ये तो पार्ट है इसलिए नहीं है ना
Well, interestingly, one of the state Waqf board is before your lordship supporting this. I will point out, my lord, I'll point out.
Lordship, in a very quick minute, Lordship. Lordship,
To state.
it's already been said that
That's the only good
my lords may grant us tomorrow, my lord, because
No, sorry.
my lord, there are good, my lord, important points which I have taken in my
Lordship, mine is the fifth matter out of the lead
Just
matters.
3 minutes, my lord. I will not
Four have
take
been
more than
covered.
3 minutes.
We had requested all
My
of
lord,
you
on the religious
time
ones,
in 2 hours.
in the
We have
context.
given you almost twice of that.
Lordship, we
In the
have no
context of
we have
religious,
no
if your
control
lordship
of that,
would consider my application, everything has been detailed, my lord, everything has been spelled out in that.
Lordship,
Lordship may kindly
Lordship,
give us tomorrow, my lord, 5 minutes.
Please don't do this.
2 to 5 minutes, my lord.
Lordship,
So you give your notes.
Lordship, I appear in one of the lead matters which have already been selected as a matter that have to be heard. Lordship, I'll just take
We
2
had
minutes.
requested you to fix up timings among yourself.
Lordship,
Instead of
that's
2
not,
hours, we have already granted you 3 hours 45 minutes.
Lordship, as the youngest member of the family, that's not something I control, Lordship. So I'm just asking for 2
This
minutes
is
of my
not
lord
fair.
and
My-
Duchess
This is not
to make points which have not been made so
Okay,
far.
2 minutes by the
My
clock.
lord, 2
Very well.
minutes for me also.
Please.
Okay.
I shall be grateful, grateful.
Okay, chalo.
Obliged. My lord, now that that's a judicial order, my lord, we can do nothing.
Rather than having
The written submissions filed by the petitioners, my lord, contain several other issues, my lord.
जरूरत नहीं पड़ेगा, thank you.
Lord, my apologies, my lord. Initially, my lord, when the matters were heard, there were three issues identified for the purpose of stay.
That's not
Because
true.
prayer is praying stay of the statute. Lord, I have filed my affidavit mentioning specifically that in view of the discussion which took place, I am filing this reply for the three issues. But the written submissions have come, which deals with, my lord, many other provisions also. My request would be, my lord, that kindly confine it to the three issues as already identified.
Well, I'm sorry, Marat. This is entirely, I'm sorry to say my great regard for my learned friend, Marat. Matter was listed earlier, then it came up later saying, the judge saying that I will, the Chief Justice, then Chief Justice said, I will hear the matter and see what further interim orders are to be passed.
No,
That's how
my
the
lord,
matter
all of
came
us
up.
were there.
I don't want, Marat,
All of us
we
were
have,
there.
we have made our submissions. We gave them in time to him. Marat, those matters are already in the petition, Marat. My learned friend can't say that I will only argue on three issues, Marat. I'm going to argue on the issues, Marat, that are in fact most important in the case, because this is a case of capture of the entire Waqf properties. That's what it is. But Malat, I'm going to argue on all the issues. My learned friend can't say. He can.
Lordships cannot be asked to have a piecemeal hearing. The Lordships really cannot be asked to have a piecemeal hearing.
hear him on this.
Substantive issues. 7, 8, 6,
Piecemeal,
7.
Lord, court
Learned
cannot
says
bifurcate.
confined to 3.
My learned
That is my request.
Hearing only on the question of grant of interim.
Correct. That's also broadly, Malat. I tell your lordship that.
3 points I have said, my lord, contemporaneously in my affidavit in reply, para 4, that at the outset it is respectfully submitted.
Where is that order? Where is that order?
Only a minute, Mr. Sibal.
No, but you are saying there's an order of the court. The
Please
court said
allow,
that.
this is not disputed, it is stated on affidavit.
His statement was
By an
limited.
officer who was present in the court, filing a prelim only to deal with the issues flagged during the earlier hearing on 16th April 25.
We were there, Malat.
This is contemporaneously filed, contemporaneously reported everywhere. I leave it to your lordship. I wanted to flag this. This may not be fair to the court,
Because
fair to the.
neither of us is party to those, we are not aware of what happened in.
There was no truncation of issues.
There is none, Malat. In fact, the order said,
no
we
dispute.
clarify. We clarify that the hearing fixed on the next date will be a preliminary hearing, and if required, interim orders will be passed.
Let's
This is
read,
nothing
my
to
lord,
do
the
with three
first order.
issues.
Let's read the first order. My lord, the first order which Mr. Sibal is reading, 17th April
Yes, yes,
25.
yes.
Yes, I'm reading that.
Please do.
Lord, please see. Your lordship, say, my lord, I'll, my lord, please.
Let him say what he has to say.
Lord, can I read, my lord? I'll just read, my lord, and leave it at that, my lord. This can't be the, not that we don't have answer to other questions, but this would be unfair to the court and unfair to the other side. During the course of the hearing, Mr. So-and-so, that is myself, stated that respondent would like to file a response within a period of 7 days from today. He assures this court that till the next date of hearing, no appointments would be made to the Central Waqf Council and Waqf boards. That was the first issue flagged, section 9 and section 14 respectively. Then I'm skipping because that's section 19, 14, etc. is mentioned. It is also stated that till the next date of hearing, no Waqf, including a Waqf by user, whether declared by way of notification or by way of registration, shall be denotified. This is pertaining to section 3R, where we have deleted the Waqf by user prospectively from hereafter. We take these statements on record, rejoinder to be filed. Thereafter, my lord, the court directs that 5 will be the lead petitions. And it was 7 days because, my lord, it was 3 issues, my lord. And thereafter, my lord, the court at the end said, we clarified that the hearing fixed on the next date will be a preliminary hearing, and if required, interim orders will be passed.
That's all.
Lord, this is what, my lord, all of us were present.
So were we.
Court had flagged these issues, but my lord, I don't wish to, my
Lord,
lord, embarrass the bench. It would be unfair, my lord, that's all I'm saying.
Can we go into that? Because if you are saying, all of us are saying that because decided they will deny it and you can't go
The
now.
denial would be unfortunate, but my
Well,
lord, I
in
don't
fact, the
want to.
statement is unfortunate, not the denial.
And we can't go and ask or other
No, sir.
creditors.
My lord, I don't wish, my lord, your lordship.
We will have to go by whatever is the record.
Yes, my lord, but I have said on affidavit that since these three issues were flagged, my reply is confined to three.
My lords, what happened was in a
And there is
fair-
no denial in
my
the
learned
rejoinder.
friend will realize what happened was the court came and the court said, look, give me an answer on these three. The court did not say, and that's why the court later said, you please argue the whole matter, and that's why it was fixed for interim orders.
The afternoon
That
hearing
was an
time was
afternoon.
fruit-
Well, we-
brought. It's not that there were truncation of issues like this. This was done. It was then was for continuation, in fact, for extending the orders on other points, either way. Not any limitation. of-
Anyway, as it is, we have paucity of time. Let's go on with the matter.
Plus, today the written submission is as virtually reading, arguing the entire writ petition itself, with all due respect. When the reply is confined only to three issues, plus their written submissions.
We have given them 2 hours. They have to decide as to how they will.
That's why we want to start and let's
Yes.
finish. Mullahs, in
But
2
I
hours.
just flagged it and leave it at that. my
We
lord.
can't go into that inquiry.
I understand.
We
it's
can't ask the learned judges. as to-
it's unfortunate, but I leave it at that.
Normally, we go by whatever is there in the black and white in the order sheet.
Yes, my lord, we sometimes trust, my lord, the other side will not
Come
take
on,
us.
Amit,
understand?
No, that's an
Request
unfortunate
for the
statement to make.
I don't
orders
know
is-
why.
That's an
Let's,
unfortunate.
let's,
Anyway,
So Mehta,
I leave it to, my lord, let them argue.
I'm feeling happy that I have only 6 more months left here.
We are not happy, my
So
lord.
my experience of 18 years in the High Court,
But we have-
compared to the 6 years here, that's been much better.
My lord, that I can also say, my lord, for High Court, my lord, because I have also come from High Court, so is my learned friend.
but those practices are not being followed here, Mullahs, despite the fact that people come from the High Court.
Yes, my lord. So we learn wrong things, my lord, from our seniors.
That's the problem.
Yes.
Anyway, Mullahs, I think
Then let's proceed, yes.
let's proceed. No, Mullahs, kindly just leave your paper book for the moment. I'll tell your lordships what the contours of my submission are. Mullahs, this is a case in which the 2025 Act has been framed, Mullahs, for the purposes of protection of Waqfs. But in reality, it is designed to capture Waqfs through a process which is non-judicial, through a process which is executive, through a process in which those to whom this property belongs, because Waqf can't be created without, except through private properties owned by the individual concerned. So private properties are being taken away only because there is some dispute. We don't know what the nature of the dispute is. And when that dispute happens, Mullahs, a person is appointed who is higher than the collector, and that person will decide the dispute on his own. He will give a report, but by the time, Mullahs, that report is given, we don't know have the time frame. And within that, Mullahs, while that report is pending, the Waqf property is taken away. And this,
Taken away without following due process?
yes, and without following any procedure. I'll demonstrate all that to your lordships. Taken away with, and Mullahs, the dispute is whether this is government property or my property. He will decide that. He is a nominee of the government, Mullahs, who is higher than the collector. So the government decides its own dispute without any judicial procedure. And while that dispute is pending, while that report is pending, the property is taken away. It is no longer Waqf property. And there is no procedure. And anybody can create a dispute. So this is one aspect of the matter, which is in the context of what I say, it was designed to take over and capture Waqf properties. That's number one. Number two, Mullahs, what is a Waqf? A Waqf, Mullahs, is a endowment to Allah, to God. A dedication to Allah, to God. And that, pursuant to that dedication, Mullahs, that property can't be dealt with in terms of transfer. You can't transfer that property to anybody. Once a Waqf is always a Waqf. That's the very concept of a Waqf, Mullahs. In other words, if I have, Mullahs, in fact, dedicated my piece of property, because I cannot dedicate somebody else's piece of property. And the historical reason behind it, let me just tell your lordships that, is that, as your lordship knows, under our constitution, Mullahs, the state cannot possibly finance religious institutions. Cannot finance, Mullahs. If there's a mosque, Mullahs, the state cannot finance it for its upkeep. If, Mullahs, there is a burial ground, this has to be created through private property. So what happens is, Mullahs, that people at the end of their lives, Mullahs, give their private property dedicated to God. so that those who come later, Mullahs, can take advantage of that property. There are no earnings there, Mullahs. If you go to a burial ground, Mullahs, nobody earns. People come to bury their dead bodies, Mullahs, and they charge a certain amount through which they maintain that. If you go to a mosque, Mullahs, there's not a chadhava, Mullahs, like in temples. They don't have 1,000 crores, 2,000 crores, 3,000 crores, Mullahs. There are no chadhavas on mosque, in mosque. So those have to be maintained. And how are they going to be maintained? Through the kind of monies that we collect through processes, Mullahs, of charity. That's all.
That happens in other religions also. When temples are,
No, but temples, Mullahs, people give, as your lordship knows, Mullahs, there are
Yes.
chadhavas that are given, Mullahs, and temples are, in terms of Mullahs, the
but even in the,
mosque,
I visit dargahs also, I visit churches also, everybody.
dargahs and mosques,
You have to,
dargahs and mosques are different. Dargahs and mosques are, I'm talking about a mosque, Mullahs. Your lordship is right. On dargah, it's different. But I'm talking about mosques. So what I was trying to say was, Mullahs, the ways to preserve these properties is through these kind of efforts that are made by the community, right? Now, Mullahs, what they say is that if anybody, supposing an encroacher creates a dispute, that property will lose its character as Waqf property as long as the dispute is pending. This is what the Act says. So you have a situation, Mullahs, where actually there was a Waqf Act. You just note this, Mullahs. There was a Waqf Act of 2013. 2013. Will you allow me? 2013, then, 1913, 1923, 1913, 1923.
First in 1923.
1913, 1913, then 1923, then
1913, 1913. 1913.
1913, then 1923, then 1954, then 1984, then 1995, then 2013 and 2025. This is, Mullahs, the history of it. Yes.
Just factually, 84 and 2013 are amendments, not the.
No, I'm talking about the Act.
Yes.
Correct? So, Mullahs, therefore, and I will demonstrate to your lordships that the 2025 Act is a complete departure from the past. I tell your lordships how. There are two concepts in law called Waqf by user and a dedication which is made, right? If you give a dedication, Mullahs, and you pass away, and that property is used, Mullahs, for the purposes of the dedication, it becomes a Waqf by user. And it's perpetuity. That's the concept of Waqf. Once a Waqf, always a Waqf. Right, Mullahs? Now that Waqf by user has been done away. A concept that is recognized in the Babri Masjid case, saying Waqf by user is a practice, a religious practice that has continued for hundreds of years. That's the 5-judge bench, Mullahs. And whether it's a Waqf by user or not is a matter of evidence. But they've done away with it. How have they done away with it? They say that in the 1913 Act, the 1923 Act, the 1954 Act, and the later acts, there was a requirement for registration. And because you did not register, Mullahs, therefore, any Waqf which is not registered will not be regarded as Waqf. So many of these Waqfs by users were created 100 years ago, 50 years ago, 200 years ago, Mullahs, 500 years ago. Where will you
But
get
is
them?
it a matter of fact that under those enactments, 1913, 1923 and so on, is there a requirement for registration?
There was.
So is it a mandatory or?
It will, no, they shall be registered, they said. But Mullahs, the consequences of non-registration were not set up in the Act. The consequences of non-registration, this is the first time in the 2025.
I have not gone through anything because I had.
You know, that's why, Mullahs, I'm broadly telling your lordships what my submissions are going to be.
I have not gone through. I'll be frank, so you'll have to start from ABCD.
Yes.
Just as a matter of information, as whether under the old Act,
Yes.
the provision was for registration was mandatory or directly?
The expression used was shall.
Merely using shall may not make it mandatory.
Correct.
were there any consequences provided in those acts for non-registration? If consequences are provided, then it will be mandatory. Whether word shall is used or not.
No, Manoj, the consequences were not that it will not be regarded as a Waqf. That was never the consequence.
Was there anything that on account of registration of a particular?
You won't be regarded as, no,
Something
that's,
will happen.
no, there's no consequence that you will not be regarded as a Waqf. It will continue as a Waqf.
But there were consequences.
No, not this consequence.
No, but
No,
there were
no,
other
For the
consequences.
caretaker, there may be consequences, but not this.
We will record your submission
Yes, please.
that though under the old act, there were requirement for registration, but they were not mandatory because the consequences for non-registration were not provided under those acts.
For the purposes of deciding,
On account of non-registration,
yes,
nothing was to be happen.
yes,
Like suppose if there is under certain act, mandatory duty is there. You have to do such and such thing within a particular period.
correct.
And if you don't do that, then you will be required to pay 1,000 rupees fine or 1 lakh rupees fine. So no such provision is there.
No, the only thing was, Manoj, that the act said that the mutawalli who has not done it is made culpable. That's all. He loses his right to continue as a mutawalli.
That's all. There
So
was
that's all. That I said to your lordship, and I stand by that. There were no consequences provided that it will no longer be regarded as Waqf.
no,
Which is,
no other consequences were there.
no other consequences. Which is why the 2025 takes that away.
So
Therefore, it's a complete departure.
so do we record that?
Yes, your lordship may record it. It's a complete departure from the
No, that
19
under 2013, sorry, 1913. Till order, the last one, 1913 till 2013.
till 2013. The status of the Waqf,
2013,
yeah,
though,
the status and character of the Waqf.
though
continue.
there was a provision
Yes,
for registration of
yes,
a work.
yes.
No consequences were provided.
Right.
Were provided for non-compliance,
Right.
except removal of a mutawalli.
Correct, because he is responsible for registration of the Waqf.
So there, except removal of a mutawalli,
Yes. Consequences quay the mutawalli.
not a trust, not a work.
Correct. Well, that's for the community, Malat. So because he did not register, he will suffer the consequences, but the character of the Waqf will not change and cannot. This changes it. I'm just giving your lordship broadly. This changes the character of the Waqf. It says if you're not registered under these acts, then you're no longer Waqf. That's number one. Number two, if you are a Waqf by user, you must tell us as to who is the one who established the Waqf. Now, how do we know? If it is established 200 years ago, how will anybody tell you today who established it? Because there was no registration at that point in time. They were user. That is why Waqf by user is a matter of evidence held by the Constitution bench of this court.
1913 to 2013.
Yes. Well, the 23 was the first one, actually.
Whether during 1913 to 2013,
Yeah.
registration was not necessary insofar as work by user is concerned.
Yes. They have now removed it completely.
Was it permissible under the?
Yes. Yes, throughout, Manoj. Otherwise, I wouldn't be making this submission. Works by user, this is established practice, recognized by
Yeah,
the Constitution bench of this court.
second submission is that prior to 2025, work by user was not required to be registered.
What happened was, Manoj, in 1954, for the first time, there was a requirement of registration as such. Otherwise, 23. Yes. मैं कह रहा हूँ यार तुम बोल रहे हो गलत बोल रहे हो। Your
2025,
lordship may say prior to 1923 or prior to after 1954, Manoj, what happened was when the British were here, they didn't want to interfere in the practices, religious practices, control provisions or management provisions in those acts. But in 1954, it became mandatory that you must register. Now, who was to register? The Mutawalli. The Mutawalli was not
Prior to
registered.
1954,
Yes.
registration of work by user was not necessary.
No, nobody was questioning Waqf by user ever. Till date, nobody is questioning, except this act, except the 2025 Act.
Probably you have not understood the question. What we are only asking you, was it mandatory or required to be registered as a Waqf under the acts prevalent at that relevant time as a Waqf?
After
Maybe by
1954,
Waqf
yes.
by user.
After 1954, yes.
Yes. So
Yes.
after 1954.
Yes.
the registration was mandated. and
Mandatory.
it had to-
Even insofar as work by user is concerned.
Yes. Even by Waqf by user. All Waqfs had to be registered. Mutawalli had to register them. If he did not register them, then consequences followed way here.
on the Mutawalli.
That
But
we'll see into
the
that.
Waqf property did not lose its character as Waqf. That's the point.
So according to you, prior to 1954,
Yes.
registration of work by user was not necessary and it became necessary after 1954. Was not necessary.
2025.
I'm saying that, but these fellows are either saying 23 or.
Only after 1954 it became necessary.
Yes.
Only after 1954 it.
Mullah, there is some confusion on this, maybe after 23, after 1923. Your Lordship may write 1923 because,
Okay,
Yeah.
so we'll write,
say 1923, Mullah, not
we
1954.
are recording everything so that we can call upon them to answer all.
1923 because I've read the act myself. That's why I was saying 1923. 23, Mullah.
Problem is that
All Lords,
so much of pressure,
yes.
not only builds pressure on us, but also on you.
Yeah, exactly, Mullah. I got different discordant voices here.
So therefore, we are,
Yes, just I show you that the 23 Act says within 6 months from the commencement.
first
Yeah,
we'll record your proposition
yes.
so that
Yes, so that we know, Mullah, what.
Not to disturb Mr. Sibal, Manoj. He's continuously being disturbed from all.
That's all right, don't worry about it, I'll take care of it.
Yes. Sir, you must.
he is trying his best. We can see it in a better manner.
Yes, Manoj, may not disturb.
We can see it in a better manner. He has tried at least half a dozen times.
So, therefore, that's the proposition. Let's make it 23, not
Okay,
54.
23. After 23, it was necessary.
Yes, necessary. But no consequences square the dedication.
So that we already recorded.
Yes. So, Mullah, that's the second proposition. You take away Waqf by user. Third proposition is, Mullah, just note two dates, 1904 and 1958. These acts relate to Ancient Monuments and Archaeological Sites and Remains Act of 1958. And there is the 1904 Act, which is also here, which is the Ancient Monuments Preservation Act of 1904.
Ancient monument.
Preservation Act 1904. So two acts, 1904 and 1958, both dealing with ancient monuments.
Both 1904 as well as 50.
And 1958. So, Mullah, when this 1904 Act came, Mullah, as your Lordship knows, Waqfs were there. Right, the
The
dedication.
works were from centuries, we are saying that there.
Waqfs have been there, Mullah. So what the Act did not interfere. For example, Mullah, you have, say, the Jama Masjid or any other places of worship. It's a Waqf, but it's getting dilapidated. Right? So the government can say, we want to preserve this property. We want to make sure it doesn't get dilapidated. And therefore, they give a notification saying that for the purposes of preserving the property, it is declared as an ancient monument. Right? But it doesn't lose its character. It doesn't mean that you can't go and pray there.
So, though it is preserved as an ancient monument, but
No ownership was transferred to the government. And it doesn't, you couldn't stop the user of the Waqf property for the purposes of the dedication. You couldn't change the identity either.
like in Khajuraho,
Correct,
there is an
Exactly.
ancient temple
correct,
where, though it is in the custody of the
exactly,
archaeology department,
correct,
being a heritage structure, still the people can go and pray.
exactly, exactly. So Malas, now the 2025 Act says, moment it's declared or it has been declared as an ancient monument is no longer a Waqf. That's why I said it's a complete taking over of Waqf properties of a community. Complete takeover, including ownership. Before or after?
No, but does it take away your right to practice your religious
Yes,
practices?
yes, I will demonstrate to the declaration itself is void.
Are you stopped from going and praying there?
Yes, declaration of the Waqf is void. It's not about whether I can, it is void.
Should we record that?
Yes, that's the third proposition.
Fourth.
Yeah.
Sorry, third.
Yeah.
On such declaration
Yes.
as a.
On or before,
On
Mother.
such declaration as an ancient monument.
Yes, as a protected monument
Such-
or protected area.
So, Mr. Singh, we would appreciate if there is only one voice from one side. It has been difficult for me to,
Area under the
for last 6 years to, but then,
No, it says Ancient Monuments Preservation Act 1904.
so on such
Ancient
declaration
monuments,
as a protected monument,
yes. Or protected area.
protected area.
Under the Ancient Monuments Preservation Act and Ancient Monuments and Archaeological Sites Act of 1958, at the time of such declaration,
Under the
and-
said act,
yes. And it should, Waqf property shall be void.
no, but does it also take away your right to go and practice?
Once
religious
the
practice?
Waqf is void, Mullah, I can't go there. The Waqf itself, it becomes void. That's what the section says. Any declaration or notification issued under this act or under any previous act in respect of Waqf property shall be void if such property is as a protected monument or protected area. So once it is void, Mullah, how can I possibly go and?
Like, Khajuraho, I know because I had visited recently. It's all with, now under the custody of archaeology department because all those structures are heritage structures. But still there is a temple wherein all devotees can go and
Yes.
pray.
Yes.
So therefore, I'm asking whether this declaration would also take away your right of going there and praying, offering prayers and all that.
Well, the problem is,
Maybe because it will be declared cease to be work because the maintenance and everything of a heritage structure is on a different yardsticks.
but if the Waqf is void itself, that means it's no longer a Waqf. And it's not my right anymore, Mullah. When you say Waqf is void, it's no longer a Waqf.
But is it your also, is it your also contention that on such declaration,
Yeah.
all religious practices which were being undertaken earlier would also not be permitted?
Manoj, it's my case that this provision is violative of 25, Article 25 of the
So should
Constitution.
we record that?
Yes, please. It's
What will be
expropriatory.
void
Yes,
and the right of the citizens
Yeah.
to continue with their religious practices.
that's correct. Article 25 and 26.
Their religious practices will be taken away.
Taken away. Therefore, it is expropriatory.
Mr. Mehta, you can ask someone to record all this.
But I am recording it. It's factually incorrect in my.
We are not asking you, we are not
I'm
asking.
recording.
You argue when your turn comes.
Yes, I'll argue when my turn comes, I'm recording.
We are only asking because since we are recording, we will be calling upon you to answer this thing.
Obviously, I'll have to answer.
The rights of the citizens to continue their religious practices will be stopped and therefore violation of 25 and 26. So what we are recording on such declaration under the Ancient Monument Preservation Act as a protected area. The work
Monument or area.
the work will be void
Yes.
and the right of the citizens to continue with their religious practices will be jeopardized and therefore violative of Article 25.
25, 26 and 14, Malat, because how do you declare something to be void, which because the perpetuity of the dedication is lost.
Article 14, 25 and 26.
Yes, I'm good.
Yes.
Because only Muslims are there.
Yes, sir, I know, only Muslims, of course.
So
Don't want-
you should have invited all of them for dinner yesterday and so that, that would have been better. Now everybody is advising you here.
I forgot.
Well, that's the other important thing that your lordships will know. This is a corollary to this proposition, is that under the Ancient Monuments Act and these two acts, my right to religious worship was preserved,
So that,
despite its declaration. Under the acts themselves, it was preserved,
and now it is being taken away
and now it is taken away.
under the said act.
No, it was preserved.
Right to religious practice of preserved.
Yes.
Yes.
Right? I mean, it says that a protected monument maintained by the central government under this act, which is a place of worship or shrine, shall not be used for any purpose inconsistent with its character. So it was preserved, taken away.
16.
That's 3D, Malaj. Sorry, 1 second.
Section 3D.
This is the present 2025 section is 3D. D, capital D. Next proposition, Malaj. That I have to be a practicing Muslim for 5 years before I can create a waqf. So, Malaj, at 77,
One has to
Right.
be a practicing.
Muslim for 5 years before I can create a waqf. So who will decide that? I guess they will come home and ask
Could
me.
be section.
ER.
This could be
3R,
3R.
yes,
R capital or
small R, Malaj. So, Malaj, I have to ask whom? And if I am on my deathbed, I'll have to say, and I want to create a waqf and dedicate it to God, then I'll have to demonstrate to them that I'm a practicing Muslim. I mean, it's per se unconstitutional, per se. It's my right under 25. It's my right under 26. And you take that away through a definition of this nature. Then, Mullah, you have scheduled tribes in tribal areas, Mullah, where Muslims are scheduled tribes.
Yes.
Correct? They say in those areas, these properties will be declared not to be waqf properties. That's 3 capital E. No land belonging to members of the scheduled tribes under the provisions of the 5th schedule or 6th schedule shall be declared or deemed to be waqf properties. On what
old
basis?
ones also go, according to you?
Yes, everything goes.
Assuming there is one work and registered, that also is.
Yes, absolutely. Shall be declared or deemed to be waqf property.
Act to the no.
I'll come to that. No, this is just the proposition. Right? So therefore, 3E is per se unconstitutional.
3E.
Yes.
What is your proposition so that we can record it?
3E, Muller's sets out, states
Will you
that
tell us your proposition.
the proposition is that if a scheduled tribe, Mullahs, who are Muslims, they have waqf property and they are practicing Mullahs, or willing to create waqf, then that waqf is deemed to be, not deemed to be waqf property at all. So therefore, that's also expropriation on the face of it. And their right under 25 is taken away.
Will be deemed not to be.
Waqf property. And cannot be declared as waqf property. And we've given a schedule of all the of the tribes, Mullahs, of Muslim population. We've given a list. We'll give.
This is according to you, by virtue of this, all works created earlier
Yes,
of
Even,
properties
yes,
come to
everything
SC and ST. Will also be.
everything goes.
Muslims, that is his case.
I'm not saying, I said scheduled tribes. Did I say anything else?
Muslims.
I said scheduled tribes.
Yes.
That's what the section says. according to us per se unconstitutional. Then, my lords, the next one is the right of management of Waqf properties has been taken away. Because the Central Waqf Council members of the Central Waqf Council, majority of the members of the Central Waqf Council are non-Muslims, maybe non-Muslims.
Because majority of
The members of the Waqf Council may be non-Muslims. It's 12A.
of the
Yes, it is. That is section 9, my lords, relates to,
council
yes, Central Waqf Council.
would be non-Muslim.
Majority can be non-Muslim.
Can be or would be.
It can be, my lords. That means they will have a majority if they choose to nominate, my lords.
Can be non-Muslims.
Yes. And on the calculation, it is 12 non-Muslims and 8 Muslims. Not sorry? And 10, sorry, 12 and 10, not 8.
12
And
non-Muslims.
12 non-Muslims, 10 Muslims. And nominated. And then section 14 also, my lords, relates to
This is section,
14, relates to the composition of the board.
but this council is.
This is 9. This is section 9. 14 is for the board.
And 23 for the CEO.
Composition of the board. Earlier, Maharaj, the board members were elected under the previous act, and they were all Muslims. And now, Maharaj, it's fully,
Elected by.
and now it's elected by the various organizations through which they came. I'll just show to your lordship that. Electoral colleges, Maharaj, of Muslims. They elected members, they were all Muslims. Now they're all nominated.
In the boards,
Yes, on the board, all nominated.
even in this Central Waqf Council also.
Yes. Those were also nominated under the previous acts. But they were Muslims. There the majority was 12 to 10, as I told your lordships. Here they are all nominated.
In the board.
Yes, all nominated. And it will be 7 to 11. 7 will be maximum, will be non-Muslims. 11 will be non-Muslims.
11
It will be total,
7 can be.
11 total, 7 can be non-Muslims. But all nominated. So the electoral college process has been done away. So they were, in a way, they conceptually capture the waqfs. They expropriate the property.
Out of 11, 7
Can be
non-
non-Muslims.
can be.
Yes. And all nominated. So, Mullah, that itself is violative of 25 and 26. Your lordship knows management has to be done by the community.
But also the CEO.
Yes. Yes. And then section 23, the CEO is to be appointed by the state government.
View of the.
CEO of the board shall be appointed by the state government who actually runs the board. And he'll also be a non-Muslim. Earlier Muslim, now non-Muslim. So the government will, in fact,
It's not mentioned non-Muslim, I think it should.
no, it just says nominee of the state government.
That's right, only nominee,
Yes.
can even be a Muslim. That's for them.
Earlier it said Muslim, has to be Muslim.
They were specifically.
Yes,
required.
that's why I'm saying, Maharaj. It's an absolute departure. Original said there shall be a full-time executive officer who shall be a Muslim. Therefore, Maharaj, all I'm giving your lordships is that this has nothing to do with all the legislations that happened earlier. This is an absolute departure and an attempt to take over through creeping acquisition Waqf properties.
This
And
is section
This is 23.
23, Maharaj,
23.
23. So broadly, Maharaj, broadly, these are the issues. Right? That out for the moment. There are other issues, Maharaj, but what is this?
Today we are
Only,
for the interim relief.
that's right. Now, Maharaj, now,
The presumption is with regard to the constitutionality.
that's correct. And
And normally the court should not
correct,
say the,
correct, absolutely.
so unless you make out a very, very
Strong case.
hearing case.
Yes, correct. And your lordships have done it in the past, so I won't go into that at the moment. Now, let's kindly have a look at the act now. I'll demonstrate each
They are
one.
not saying they are powerless, but then the case which has to be weighed out.
Absolutely, absolutely. Which is why I'm trying, which is why I'm trying.
Otherwise, the presumption is with regard to
Of course.
procedural statute.
But what?
That's the law which we have been taught from
The problem,
colleges.
the problem is you have to decide it on
And,
the basis.
And in the light of the present.
Lordships need not say anything more.
I won't say anything more.
Well, therefore, we have to make a prima facie case, which is what I'm trying to do. We have to demonstrate to your lordship the balance of convenience in our favor, and irreparable injury will be done if these provisions are activated. That's what we have to demonstrate. So if I can't create a waqf unless I demonstrate 5 years of being a Muslim, and if that is operated, it's an immediate injury, it cannot be. It's irreparable. If a government officer above the rank of a collector is to decide a dispute between the government and the waqf without reference to any judicial procedure, it is irreversible. The question may come from anywhere.
So there's a finality to the
Yes.
decision of that officer.
Yes, fine. No time period, finality. I just now, let me just now.
Finality to the decision of the collector.
Well, what happens is under section 3C, if there is a dispute to a government property or a property of a government organization, supposing the district collector or the government feels that this is our property, let's assume, then an officer is designated above the rank of a collector, right? He will then give a report. The time frame for that report is not set out. While he is contemplating to give a report, the nature of that property as waqf is done away with.
So even before that report is
Yes,
there,
even that report is fine.
Shall not be treated as.
It shall not be treated as waqf. So this is irreparable.
So this is under section.
3C, 3 capital C. Proviso.
Under section
3 capital C proviso.
the
Capital C
what is
proviso.
called designated officer.
Yes, designated officer above the rank of a collector. It says that he'll conduct an inquiry, quote, unquote, as per law, no law, whether this is government property or not, and that property shall not be treated as waqf property till the designated officer submits a report. So therefore, before the inquiry,
So designated officer, when he conducts an inquiry,
yes,
during pendency of inquiry, that property can be taken away.
it is no longer waqf property. It can't be treated as waqf.
The moment the inquiry is initiated,
Yes, it can't be treated as waqf.
for all intents and purposes,
Yes.
it ceases to be a,
It ceases to be a waqf
without any declaration.
without even an inquiry, because he's yet to have the inquiry. He's yet to conduct an inquiry. And there's no adjudicatory process there.
Of property.
There's no
So
adjudicatory.
without, even if somebody raises a dispute,
Anybody.
Yeah, anybody can raise a dispute.
he well was, we know that we know your enthusiasm. Give him benefit of his experience of more than 50, 60 years at the bar. You can be comfortable if some chair is available, otherwise you'll ask him to provide.
Take seat, take seat.
Sit down.
So, during pendency of the inquiry, it will cease to be a work,
Yes,
and everybody would be stopped from continuing their practice.
absolutely.
Whether they are also entitled to take away the possession during the pendency of the inquiry.
Nobody says no longer a waqf, that's the end of the matter. It's not be treated as a waqf. So how do I exercise my rights under 25, 26?
Citizens cannot exercise their rights of religious practice.
That's not going to. Now, once he submits a report, normally the procedure in law is not prescribed under 3C as to what inquiry is to be conducted. He doesn't have to go to a tribunal. He doesn't have to go to.
There's a finality to his decision.
There's a finality. Once he submits the report, the revenue records will be amended accordingly for him. And the board will be given a direction that you also correct your records that this is no longer Waqf property. That's the consequence. I will. I'm just hold on.
Revenue record and board records will be required.
Yes, will be required to be amended. And this is without any judicial process at all. Now, what's more interesting, and this connects to Mullad's a very important argument, that under 83 of the 2025 Act,
Under
Section 83 of the 2025 Act deals with constitution of tribunals.
section
83.
83.
Yes. Now, Mulad, what happens is that once under 3C, it is no longer a Waqf, then I become the aggrieved party. Only I can go to the tribunal. Government is not required to go to the tribunal to find out whether it's Waqf or not. So through an executive process, you decide on what the nature of that property is. You don't go to a judicial process, and then you force the Waqif or the person aggrieved to go to the tribunal and say that, no, this decision of the collector was wrong. Now that will take 5 years, 10 years, 15 years, and even if it comes in my favor, the nature of the property is gone. The most egregious provision, Mulad, inconsistent with 14.
Is required to
Yes.
go to the tribunal.
Yes. He doesn't have to go. So now, Manas, let me just read the provisions to support the.
During the proceeding under section 83,
Yes,
the status of the property is already changed. That is it taken away by the government?
correct. And I have to go to the tribunal to demonstrate.
Status of the property is changed.
Under 3C, it's already changed.
Okay. And the Waqif also loses possession.
Yes, then whoever aggrieved, whichever is the aggrieved party.
The Waqif will also lose possession of the property.
Naturally, yes. Because before the inquiry starts, it's no longer Waqf. Now, let's kindly have a look at the definition of Waqf in 3R. Just take the act now, let's. The amended.
I.
R, let's.
So now, as compared to Planet Solicitor's 3 propositions, they become 10 now.
But he'll have 11 solutions for that. Never 3, Madhus, but anyway, be that as it may. So may I just read the definition with the Lordship's permission? Waqf means the permanent dedication by any person showing or demonstrating that he is practicing Islam for the last 5 years. You also have that? Page 7 of this book. Don't you see that? Lordship has that? May I read it? It says, Waqf means the permanent dedication of any person showing or demonstrating that he is practicing Islam for the last at least 5 years, of any movable or immovable property, having ownership of such property, and that there is no contrivance involved in the dedication of such property. for any purpose recognized by the Muslim law as pious, religious, or charitable. So I don't know what this means. I have to demonstrate that there is no contrivance involved in the dedication of the property. So that's, according to me, Malas, on the face of it, unconstitutional. Why should I have to show them that I'm a practicing Muslim? And to whom am I to show that? And what inquiry is to take place? Who is going to decide that matter? In what manner will they decide that I'm not a practicing Muslim or I'm a practicing Muslim? And why should I have to wait for 5 years? On the face of it, Malas, it's violative of 14. And it's directly violative of 25 and 26. Leave it there. It's time. Show them later. Yes. Now, let's kindly see, immediately after this, over the page, you small I, your lordship sees. Just sees small I on the top of page 8 of this book.
Yes, I is deleted.
It's deleted, Malad, your lordship sees that? Kindly go to the footnote. Kindly go, what was it in the earlier act, Malad? Prior to omission, stood as under a waqf by user, but such waqf shall not cease to be a waqf by reason only of the user having ceased irrespective of the period of such cessor. Removed. Waqf by user removed. That's why I've been saying it's capturing waqf property throughout the country. Creeping acquisition of waqf properties throughout the country. Through executive fiat.
Not all. It is only limited to one category. You may say so.
No, I'll show the others also.
That's a different
Yes.
matter. But as of now, it is with regard to
yes,
one category.
only one category.
Whatever you are saying would be relevant as far as the
Yes,
one category.
fair enough, fair enough, fair enough, fair enough.
A work by user, but such work shall not cease to be work by reason only of the user having ceased irrespective of
Period of such.
So, in addition to this, there are other grounds.
Yes, I'm going to show.
Even under the earlier act,
Yes.
it could cease to be a work. Only by reason of non-user, it could not.
No, it never ceased to be a waqf by user. Never. Because it's a dedication to God, Mullah. There's no question of it ever ceasing. Because somebody else will use that property. But it can't be transferred. Kindly, Mullah, this is the whole difference between waqf as a concept, Mullah, and trust as a concept. Waqf is a dedication to God. And therefore the community will use it in whatever manner. If you have a place, a small place where people come and rest, a little small rest house, Mullah. Now, if the person ceases to exist,
Musafir Khana.
Yeah, Musafir Khana. That's a waqf. No, it can't cease to be that. This was the provision that protected it. They took it away. Now come to the proviso. Provided that the existing waqf by user properties registered on or before the commencement of this act. So now, Malas, you are now ensuring that only waqf by user which are registered are the ones that will remain. Page 8 middle. Provided that the existing waqf by user properties registered on or before the commencement of the Waqf Amendment Act as waqf by user will remain as waqf properties except that the property wholly or in part is in dispute or is a government property. So, Malas, if any third person raises a dispute, for example, Malas, an encroacher raises a dispute, it will not be waqf property.
They are abolished.
Can you see, Malas? And Malas, government property means what? Government property is defined. Now see, Malas, that definition in section 3, small fa and fb, page 6 of this statute. Kindly read 3FB first. Government property, page 6. Government property means movable or immovable property or any part thereof belonging to a government organization. Right, Melissa? Then government organization is defined in 3FA, just above this. Government organization includes the central government, state governments, municipalities, panchayats, attached and subordinate offices, autonomous bodies of the central government, state government, any organization or institution owned and controlled by the central government or state government. So, Maharaj, in fact, every organization is covered under this act. A panchayat is covered. So, if a panchayat raises a dispute, that's the end of the Waqf. I just read that proviso to your lordships. Any dispute, local panchayat, municipality.
But will it automatically cease to be a work property?
It is. I'll show you 3C, Malad. That hones into 3C, capital C. Now just read 3C with me after having seen this. Then I'll come back to Malad section 3B.
So we'll
Just come to 3C after this.
So according to you, in view of proviso, the same work property will cease to be work property.
Yes. And it's quay Malad, any local authority or any dispute raised by anybody. Yeah. And Malad, in 3R you have is in dispute or is government property. So it may not, dispute may not relate to government property at all.
Maybe between
It's a private person.
two individuals. So
Exactly. Then also it ceases to be Waqf. By virtue of the statute, Mullah.
At Aurangabad, there are so many disputes with regard to work property.
Correct. It's in our DNA, Mullah. And it says wholly or in part. Well, let's just see the submission. Waqf by user abolished. 3R deals with registered Waqf by user. Registered Waqf by user, if there's a dispute, Waqf goes. That dispute may be with a private party or with the government. If it is government, the designated offerer will decide under 3C. He start an inquiry. Before the inquiry is no longer Waqf. So in effect, you are expropriating all the Waqf property.
What about a dispute within the private property?
That also
Waqf?
no longer Waqf. What are you trying to do? Any private party will raise a dispute. We see that happening every day, Malas. So any private party will raise a dispute, it will no longer be above. What are you trying to do? You are actually throttling.
So is it relatable to any particular nature of dispute?
No.
Simple dispute.
Simple. It doesn't define.
Doing a lessee.
Relate to that property only.
Whatever.
Relate to that property only. That's correct.
That would also include.
Yes.
That may not be. It would relatable to the.
But it's not, Malas, clarified. Your lordship is right, but it's not clarified, Malas. Malas.
Answer, you are saying that he has 11 answers, so maybe 12.
Now, Malas, kindly read 3C, Malas, capital C. That's at page 9. It says any government property, now government property, now defined as government organization and all local bodies. They're all government property. All companies identified or declared as Waqf property before or after the commencement of act shall not be deemed to be Waqf property. If any question arises as to whether any such property is a government property, the state government may by notification designate an officer above the rank of collector, as I mentioned to your lordships, hereinafter referred to as the designated officer, who shall conduct an inquiry as per law. Now, which is that law, Malad? Doesn't go to the tribunal, because only the aggrieved party will go to the tribunal under 83. We don't know what this law is. There is no procedure set out. and determine whether such property is government property or not, and submit his report to the state government. So he's a government officer. Dispute is between government and the Waqf. He will decide the dispute without any procedure. He'll be a judge in his own cause, and proviso, provided that such property shall not be treated as Waqf property till designated officer submits his report. Which is what I was indicating to your lordships at the outset, as a proposition. Yes, it's a determination. Yes. Subsection 3 says, in case the designated officer determines the property to be government property, he shall make necessary corrections in revenue record and submit a report in this regard to the state government, which is what I told your lordships. And the state government under subsection 4 shall, on receipt of the report of the designated officer, direct the board to make appropriate corrections in the records. Now then, who is then the aggrieved party? Us, the Waqf. Then under 83, I go to the tribunal. So a dispute which is judicial in nature, decided through the executive, after being a judge in his own cause, and before the inquiry starts, this is no longer a Waqf. After the inquiry is over, the revenue records are corrected, and I have to go to the tribunal for an adjudication, and God alone how long that will take. And in the meantime, my right is taken away. It's expropriatory. It's violative of 25. It's violative of 14. It's manifestly unjust and arbitrary. So that's that one point, which I placed before your lords. Now, let's kindly come back to 3B. And this 3C applies to all forms of Waqf, not just Waqf by user, all forms of Waqf. The moment this dispute is created. Now kindly come to 3B, Malaj. Which is perhaps even more problematic. 3 capital B at page 8. May I read it, Manoj? Every Waqf registered under this Act, prior to the commencement of the Waqf Amendment Act 2025, shall file the details of the Waqf and the property dedicated to the Waqf on the portal and database within a period of 6 months from commencement. Right, Manoj? Now kindly come to subsection 2. What are those details that have to be provided? The details of the Waqf under subsection 1, amongst other information, shall include the following. Kindly come to B. The name and address of the creator of the Waqf, mode and date of such creation. How will people have that, Manoj? In a Waqf by user. Waqf created 200 years ago. How do we know who the creator of the Waqf is? What is the date of creation?
Can never have a creator. Waqf by user can never have a creator. By definition, it cannot.
That's exactly the point. That's why, that's precisely the point. This is about the registered work we are talking about. Because even after registration, a Waqf by user can be registered, Manoj, he still may not know. And if I don't give it, Manoj, I can go to jail for, the Matwalli will go to jail for 6 months. Read it with 61(1)(a). Because it deals with every Waqf registered, Manoj. It may be a Waqf by user or otherwise. It applies to every Waqf registered. Kindly come to page 51, Manoj. Section 61. Page 50, section 61. If a mutawalli fails to, and kindly straight away come to Roman small 5 at page 51, upload the details of Waqf under 3B. Those are the details I mentioned to your lordships. Now, what will happen to him? He shall be punishable with imprisonment for a term which may extend to 6 months and also with fine. So if he doesn't know the name of the creator, Maharaj, he shall suffer imprisonment. Now, kindly note, sorry. Kindly note, let's go back to 3B2. Instead of B, kindly read C. He has to also produce the deed of Waqf. But after that,
Keep available.
correct, but it doesn't apply to B.
If he is not known,
Then how can, it doesn't, it should have been. Because, Maharaj, if he doesn't give the name of the creator and the date, he will be imprisoned.
we could have been better worded if available was also there.
Correct, correct. Right, so Maharaj, I have taken care of 3C and 3B, Maharaj. And also the proposition that I have to wait for 5 years as a Muslim. So those 3 I have taken care of. Now kindly come to 3D. That's at page 10. That's on the protected monument and protected area. Can I read it, Maharaj? Any declaration or notification issued under this Act or under any provisions, any previous Act in respect of Waqf properties shall be void. This is what I was trying to show to your lordships when I made that proposition. If such property was a protected monument or protected area under the Ancient Monuments Preservation Act, 1904, or the Ancient Monuments and Archaeological Sites and Remains Act, 1958, at the time of such declaration or notification. Taj Mahal is a protected monument, Mullah. Under the Ancient Monuments and Archaeological Sites. At the time of such declaration or notification. At the time. So it is retrospective. So this section operates retrospectively because many of these monuments were declared as ancient monuments even prior to independence. So retrospectively, they lose all their character. Quite frankly, I haven't ever seen an act so generous to a community as this one is. Yes. Before, correct. 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 Now, kindly see, Malas, kindly come to the Ancient Monuments and Archaeological Sites Act. No, let's go to the 1904 Act first. Ancient Monuments Preservation Act, 1904. That's in this book itself, Malas, which your lordship has. And your lordships will find it at page 54. A 1904 Act is part of the 1958 Act, Malas. Now, just kindly have a look at the definition, Maharaj, of ancient monument at page 55. It starts at page 54, the 1904 Act.
It is United Work Management Government.
No. In the same book,
Ancient monument.
in the same book at the end, you will have that. Oh,
Ancient monuments book.
ancient monument books, Your Lordship is to have.
Asian Monument Act.
Yeah. I'm sorry, yes. If it's a 2000, I have the 2022 edition.
Yes, right.
Then it will be page 54, Maharaj. Lordships have the 22 edition? Yeah, then the page is 54. This will give you an indication that the intent was never to interfere in rights of minorities under 25. The definition itself. Ancient monuments, that's at page 55. Preamble says, Maharaj, an act to provide for the preservation of ancient monuments and objects of archaeological, historical, or artistic interest. So preservation, Maharaj, that's the intent. Ancient monument means any structure, erection, or monument, or any tumulus or place of interment, or any cave, rock sculpture, inscription, or monolith, which is of historical, archaeological, or artistic interest, or any remains thereof, and includes site of an ancient monument, such portion of land adjoining it, they may require fencing or covering in, or otherwise preserving such monument, means of access to and convenient inspection of ancient monument. So Your Lordship notices here, it doesn't have any religious tone to it. Religious structure can also be an ancient monument, but the intent is to preserve it. What they've done in 3D is to say that the moment there's a declaration, then it ceases to be a Waqf. And the Waqf is void. And retrospectively. How do you defend something like this? And then, let's kindly come to page 58, section 10. Yes. Yeah, come to 6 first, Mulats. Or kindly see section 4 first, ancient monuments. Page 56. The collector, with the sanction of the central government, may purchase or take a lease of any protected monument. Collector, with a like sanction, may accept a gift or bequest of a protected monument. The owner of any protected monument may, by written instrument, constitute the commissioner, the guardian of the monument. And when the commissioner accepts the guardianship of the monument, owner shall accept, as expressly provided in the act, have the same estate, right, title, and interest in or to the monument, as if the commissioner had not been constituted guardian thereof. Whereas the fundamental theme, as far as the Waqf is concerned, is that it is my property. I cannot create a Waqf unless it is my property. And this my property is taken away through a legislative diktat. In other words, a person's property is acquired without
Section 6.
section 4, Maharaj, I was showing to your lordships. Declarations are under section 3 or protected monument. 4 says that, look, it can be purchased, it can be taken on lease. 5 says there has to be an agreement for preservation. I don't want to read all of it, Maharaj, because there's not enough time. It's only prima facie. And then section 10 says compulsory purchase of ancient monument if the central government apprehends that a protected monument is in danger of being destroyed, injured, or allowed to fall into decay. The central government may direct the state government to acquire it. This is not the case. Here, pursuant to a declaration, the acquisition takes place, and the Waqf is void. and says the powers of compulsory purchase conferred under 1 shall not be exercised in the case of any monument which or any part of which is periodically used for religious observance, or any monument which is the subject matter of subsisting agreement executed under 5. So the intent of the act is to preserve my right. 2025 destroys it, takes it away, expropriates it, and through a diktat. And the definition itself, well, actually doesn't talk of a religious construction. Now kindly see, Malats. Let's go to the other act now. Now kindly see the 58 Act. At page, Malats, 3 of this book. Now, if your lordship looked. Yes. All these declarations, Malats, were made in 1904 and continued in 1958. And they are giving them retrospective effect to take away the Waqf character. Now kindly see, Malats, the definition itself at page 3 is the same as in the 1904 Act. So I won't read it, Malats. It has no religious color to it. And then, Malats, kindly come to section 5 at page 7. It's the same, Malats. It is exactly the same as in the 1904 Act, section 4. Acquisition of rights in a protected monument, exactly the same. And it says subsection 6, just note that, Malats, at page 7, nothing in this section shall affect the use of any protected monument for customary religious observances. So the intent of both these acts was never to take over, Malats, the rights of a minority community for religious purposes, using this property for religious purposes. Never the intent. But the 2025 is a complete departure. And then kindly come to section 13. Yeah. Well, you may have a protected monument, but actually there are many of these which have nothing to do with religious purposes also.